never been passed. Norton versus Shelby County. Let's see. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionally dates from the time of its enactment and not merely from the date of the decision so branding it. No one is bound to obey unconstitutional law, and no courts are bound to enforce it. All laws which are repugnant to the Constitution are null and void. Chief Justice Marshall, Mayberry versus Madison. Just about done. The people are sovereign. People are supreme, not the state. Waring versus Mayor of Savannah. The people of the state do not yield their sovereignty to the agencies which serve them. The people, in delegating authority, do not give their public servants the right to decide what is good for the people to know and what is not good for the people to know. The people insist on remaining informed so that they may retain control over the instruments they have created. And that is Added Statutes 1953, 1588, page 3270, section 1. The people are the recognized source of all authority that are municipal, and to this authority it must come at last, whether immediately or en route. Barnes versus District of Columbia. The government is but an agency to the state being the sovereign people. State versus Chase. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. And the law is the definition and limitation of power. The Congress cannot revoke the sovereign power of the people to override their will, as thus declared. Perry versus United States. The doctrine of sovereign immunity is one of the common law, immunities and defenses that are available to the sovereign. Will versus Michigan Department of State Police. The people of the state, as the successors of its former sovereign, are entitled to all rights which formerly belonged to the king. Private corporate state. Municipal policy enforcement. Nothing is gained in an argument by calling it police power. Henderson versus City of New York. An officer who acts in violation of the Constitution ceases to represent the government. Brooksfield Construction Company versus Stewart. That an officer or employee of a state or one of its subdivisions is deemed to be acting under color of law as to those deprivations of rights committed in the fulfillment of the task and obligations assigned to him. Monroe versus Page. Actions by officers and employees, even if authorized or in excess of authority, can be actions under color of law. Stringer versus Dilger. The police power of the state must be exercised in subordination to the provisions of the United States Constitution. Beckenham versus Wanley. With regard particularly to the United States Constitution, it is elementary that a right secured or protected by that document cannot be overthrown or impaired by any authority. Donnelly versus Union Sewer Pipe Company. The officers of the law in the execution of process are required to know the requirements of law, and if they mistake them, whether through ignorance or design, and anyone is harmed by their error, they must respond in damages. Roger versus Marshall, United States, use of Rogers versus Coughlin. It is a general rule that an officer, executive, administrative, quasi-jurisdictional, judicial, ministerial, or otherwise, who acts outside the scope of his jurisdiction and without authorization of law may thereby render himself amendable to personal liability in a civil suit. Cooper versus O'Connor. Public officials are not immune from suit when they transcend their lawful authority by invading constitutional rights. Alficio versus Woodard. Public servants, officers, judges not immune from suit. Immunity fosters neglect and breeds irresponsibility, while liability promotes care and caution, which caution and care is owed by the government to its people. Civil rights. Rabin versus Rowan Memorial Hospital Incorporated. Government immunity in Land versus Dollar. The court noted that when the government entered into a commercial field of activity, it left immunity behind. Brady versus Roosevelt. FHA versus Burr, and Kiefer versus RFC. The high courts, through their citations of authority, have frequently declared that where any state proceeds against a private individual in a judicial forum, it is well settled that the state, county, municipality, etc. waives any immunity to counters, cross-claims, and complaints by direct or collateral means regarding the matters involved. Ludenbeck versus Tekla. When enforcing mere statutes, judges of all courts do not act judicially. And thus are not protected by qualified or limited immunity. Owens versus City. Bothke versus Terry. But merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. Thompson versus Smith. Keller versus PE, FRC versus GE. Immunity for judges does not extend to acts which are clearly outside of their jurisdiction. Bowers versus Hazel. Rhodes versus Houston, Mueller versus Wechtel. Judges not only can be sued over their official acts, but could be held liable for injunctive and declaratory relief and the attorney's fees. Lesma versus Justice Court. All right. It is one of the fundamental maxims of the common law that ignorance of law excuses no one. Where there is no jurisdiction, there is no judge. The proceeding is as nothing, such has been the law from the days of the Marshalsia. And just a couple of ones on here. When a judge acts where he or she does not have jurisdiction to act, the judge is engaged in an act of treason. U.S. versus Will. Cohens versus Virginia, so on and so forth. Okay, corpus delicti. Victimless crimes do not exist. Okay. We all know that state statutes, there's tremendous amount of them that are victimless crimes. There has to be an injury or there has to be damage. And period. That's it. Anything else is not a crime. Proof of jurisdiction on the record. The plaintiff prosecutor has standing corpus delicti, which means a victim. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of the constitutional rights. Scherer versus Cullen. With no injured party, a complaint is invalid on its face. Gibson versus Boyle. Supreme Court ruled, without corpus delicti, there can be no crime. In every prosecution for crime, it is necessary to establish corpus delicti, the body or elements of the crime. Injury or damage. None of those, no crime, no arrest, no ticket. Proof of jurisdiction appearing on the record that the defendant is subject to rules, codes, and regulations. All codes, rules, regulations are applicable to the government authorities only, not human creators in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking in due process. Rodriguez versus Ray Donovan, U.S. Department of Labor, 1985. Let's say that again. All codes, rules, and regulations are applicable to the government authorities only, not human creators, in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking in due process. Rodriguez versus Ray Donovan, U.S. Department of Labor, 1985. That's it in a nutshell. And this is the supreme law of the land, cannot be ignored, has to be followed. Nothing overrides it, period. So, it's important y'all know. Okay. UCC 1201, general definitions. Person means an individual, corporation, business trust, estate, trust, partnership, limited liability, association, joint venture, and government. Then you might say individual could be a person. Look up individual. That's a whole nother. Governmental subdivision agencies are instrumentality, public corporation, or any other legal or commercial entity. American Law and Procedure, Volume 13, page 137, 1910. The word person and its scope and bearing in law, involving as it does legal fictions and also apparently a natural being, it is difficult to understand, but it is absolutely necessary to grasp, at whatever cost, a true and proper understanding to the word in all the phases of its proper use. A person is here not a physical or individual person, but the status or condition with which he is invested. Not an individual or a physical person, but the status or condition or character borne by physical person. Not an individual or a physical person, but the status or condition or character borne by physical person. The law of persons is the law of status or condition. Also see Uniform Commercial Code. Code creates a corporate state of the United States, the federal corporation, as opposed to one of the de jure several states. UCC 1201, general definition, state means a state of the corporate United States, as opposed to USC Title 28, Part 6, Chapter 176, Subchapter A, 3002, Definitions 14. State means any of the de jure union states of the several states. Proof of jurisdiction appearing on the record that the alleged defendant is not a sovereign, status corrected, American state citizen or American state national. In the United States, the people are sovereign, and the government cannot sever its relationship to the people by taking away their citizenship. Alfraham versus Rusk. Also see, the people of a state are entitled to all rights which formerly belonged to the king. Also, let's see, that's your U.S. Supreme Court, Wilson versus Omaha Indian Tribe. In common usage, the term person does not include the sovereign, and statutes employing the word are ordinarily construed to exclude. U.S. Supreme Court, since in common usage the term person does not include the sovereign, statutes employing the term are ordinarily construed. So there's several of them saying that statutes just don't go to the living sovereign. We don't live by statutes, we live by God's law. And that is the jurisdiction over us, not admiralty, maritime, police, no. All right. Men are endowed by their Creator with certain unalienable rights, life, liberty, and the pursuit of happiness, and to secure, not grant, or create these rights, governments are instituted. The property or income which a man has honestly acquired, he retains full control of. Bud versus People, State of New York. By the way, you don't have to pay payroll taxes. You never did. It's voluntarily. I signed some paperwork and sent them to the Treasury, and I was able to back up 13 years and cancel out all my tax returns. But you have to be an American to do that, from what I understand. Shapiro versus Thompson. Let's see, we went over that. That's the same things about the traffic. You have the right to travel. I think that's pretty clear by now, I hope. Or rights secured by the Constitution are involved, there can be no rulemaking or legislation which is would abrogate them. Miranda versus Arizona. The state cannot diminish rights of the people. Hurtado versus California. Alexander versus Bosworth did that. Personal involvement in deprivation of constitutional rights is a prerequisite to award of damages, but defendant may be personally involved in constitutional deprivation by direct participation. Failure to remedy wrongs after learning about it, creation of a policy or custom under which constitutional practices occur, or gross negligence in managing subordinates who cause violations. Gallegos versus Haggerty. We talked about the government being an artificial persons and just a figure of the mind. And this is something we see a lot in court. Porter versus Porter. The practice of an attorney after filing an affidavit on behalf of his client, asserting that the status of the client is not approved, inasmuch as not only does the affidavit become hearsay, but it places the attorney in a position of witness, thus compromising his role as an advocate. It's Commercial Crimes, District of Columbia Code 27 CFR 7211, Code Enforcement Officers, Law Enforcement Officers, LEOs, commercial crimes, any of the following types of crimes, federal or state, offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, so on and so forth. Which means that the so-called judge is actually a clerk working for the prosecutor when acting to enforce a statute. And its subsequent amendments to the present date, the judge of the municipal court and state court is acting as an administrative officer and not a judicial capacity. Courts administrating or enforcing statutes do not act judicially. They act as an extension, as an agent involved for the involved agency, but only in a ministerial and not a discretionary capacity. Thompson versus Smith. Keller versus PE, and FRC versus GE. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. K.C. Davis, Administrative Law, Westlaw, 1965 edition. An officer who acts in violation of the Constitution ceases to represent the government. Brooksville Construction versus Stewart. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Therefore, any so-called order the clerk masquerading as a judge issues is a fraud and a nullity. Like a warrant for arrest is a fraud and nullity, and a fine is a fraud and nullity, and he is fully liable in his personal capacity and has no judicial immunity. Where any state proceeds against a private person, the immunity. When enforcing mere statutes, judges of all courts are not acting judicially, and thus are not protected by qualified or limited immunity. Bothke versus Terrio and versus City. All right, okay. Black's Law Dictionary, 6th edition, page 868. Kangaroo court. Term descriptive of a sham legal proceeding in which a person's rights are totally disregarded and in which the result is a foregone conclusion because of the bias of the court or the tribunal. Maxims of Law, Black's Law Dictionary, 9th edition, page 1832. Fraud and justice never dwell together. Okay, all District of Columbia territorial courts, which is state courts, city court, are using their Uniform Commercial Code, which is controlled and regulated by the Unidroit Treaty, International Institute of the Unification of Private Law, which the United States Incorporated has been a signatory to for over 30 years, which is unconstitutional because the treaty power can only be used externally. Today, it is enough to highlight some of the structural and historical evidence suggesting that the treaty power can be used to arrange intercourse with other nations, but not to regulate purely domestic affairs. Bond versus United States. And you have the courts have no authority to use Unidroit Treaty in America, and they use it of the Uniform Commercial Code is unconstitutional. The government of the United States is one of limited powers. It can exercise authority over no subjects except those which have been delegated to it. Congress cannot legalize, enlarge, or our federal government jurisdiction, nor can it enlarge under the treaty-making power. Mayor of New Orleans versus United States. United Nations clerks masquerading as judges in 50 states are impersonating public officials, which is a felony. A person commits an offense if he impersonates a public servant with intent to induce other to submit to his pretended official authority or to rely on his pretended official acts, or knowingly purports to exercise and function of a public servant or of a public office, including that of a judge and court, and the position of or office through which he purports to exercise a function of a public servant or public office has no lawful existence under the Constitution or laws of this state or of the United States. An offense in the section which is a felony. And that is Owens versus Independence. Where there is no jurisdiction, there is no judge. The proceeding is as nothing, such has been the law for the days since the days of Marshall. Bradley versus Fisher, Manning versus Ketchum. A void judgment is one from its inception and complete nullity with and without legal effect. Okay. So I'm done. And if you all can see, I don't believe anybody can say that that system is one created by God. And